As children, I think we are taught to value only truth and justice, so that our teachers will hopefully sway us from a path of lies and falsehoods. In keeping with these teachings, I began my search for truth with this project on May 23, 2005. Yet what I have found is that the search for truth in history is like searching for gold. You tend to find more fool's gold than the pure substance itself. However, I have realized that maybe what I was taught is too black and white, that to hear the stories of opinion and bias is much more fascinating than hearing the stories of truth.
During the American Civil War, there were 5 infantry regiments and 1 artillery regiment of U.S. colored troops in Chattanooga. In addition to having a good combat record, these people were also used as a labor source. They built the first bridge over the river, they built the waterworks, foundries, railroads, miles of track and road. In essence, they built modern Chattanooga. At the end of the war, a group of officers from the Army of the Cumberland elected to remain in Chattanooga. And these were industrialists. They had been in their leader, John Wilder, had been in the iron business in Indiana before the war, and he saw opportunities for that here. So they remained and became quite successful. And the former colored troops became the major workforce in the foundries and industrial facilities that Chattanooga had. Now, Chattanooga had probably the greatest degree of racial equality anywhere in the country at that time. The form of government was based on wards. The city was divided into wards, and each ward elected representatives that they were called aldermen. And there were black aldermen, there were black police and firemen, there were even black representatives in the state legislature from Chattanooga.
This was before Jim Crow, right?
Yes. And there was a significant middle-class business and professional community of blacks that were highly successful in Chattanooga. And this was resented by a segment of the white population. And they began organizing to overcome it. There was an organization that called themselves 2/3 of the businessmen of Chattanooga began lobbying to change the form of government. And also, there was a calculated campaign of intimidation against the blacks. The most dramatic aspect of this was lynchings. There were 3 lynchings in Chattanooga, 1 in the jail and 2 on the Walnut Street Bridge.
Here I was, born and raised in Chattanooga, Tennessee. As a youngster, I went to the public schools. I graduated from Dickinson Junior High School, and I graduated from City High School. But when I finished high school, I'd never heard of this case. And then I went to the University of Tennessee at Knoxville, got my undergraduate degree, and majored in history. Never heard of this case. Then I went to law school at the University of Tennessee at Knoxville. Never heard of this case. So I came back to Chattanooga to start practicing law, and I had been practicing law about 8 or 10 years. And I was in the law library looking up something that had nothing to do with this subject matter. But I turned the page of the Supreme Court book I was reading out of, and I looked down, and it said, Sheriff of Hamilton County, Tennessee, found in contempt of the United States Supreme Court. And I said, Lordy mercy, what is this? And then I went to the library and started researching this, and so 30 years later, I wrote this book. It was one of the most fascinating things I had ever researched. What is famous about this book and this case, it involves two cases. The case of Ed Johnson, who was a 23-year-old black man in Chattanooga accused of raping a white woman who was 19. Her name was Nevada Taylor. She worked as a secretary downtown for a grocery company. And she lived in the cemetery at the foot of Lookout Mountain. Her father was the custodian of the Forest Hills Cemetery. And they had a house inside the cemetery. So she rode the incline out to the foot of Lookout Mountain. She rode the what do you call it, a trolley out to the foot of Lookout Mountain. Got out, started walking to the cemetery where she lived, and someone came up behind her and put a leather strap around her neck and choked her into unconsciousness. When she woke, and the doctors came, she had been raped. But you see, she was attacked from behind. She never saw the person, but she did say to them that he was black. Evidently, she could see his hands or something. When the newspapers first came out, they said, well, the difficulty is that she probably will never be able to identify the person. 3 or 4 days later, they arrest Ed Johnson and another man who was a black preacher. And they take him to jail and put him in the jail. And a crowd comes down to the jail and they're going to break in. Well, the sheriff had taken them out, the two men out, and taken them to Nashville by train, which saved their lives. But the mob did some damage to the jail, and finally they let a committee of these mobsters, I call them, go into the jail to satisfy themselves that they weren't there. Later on, the sheriff took Nevada Taylor over to Nashville and let her look at the two black men. Now notice, it didn't put them in a lineup which safeguards misidentification. What they did was, she looked at both of them and she said that it definitely was not the preacher. And she wasn't sure about Ed Johnson, but she thought maybe he was the one. How? We'll never know. But anyway, so the sheriff talked to this black preacher and said, look, how about us putting you back there and see if you can get him to admit what he's doing. You're a minister. He did, and Johnson said, wait a minute, it's not me. He denied it. But based upon that identification, and based upon the fact that someone came forward because of a reward that was granted and tried to corroborate the girl, saying that Johnson had been at the foot of Lookout Mountain, with a leather strap around his fingers and so on. Well, he got a $250 reward. Do you realize how much $250 was in 1906?
It was a huge sum of money.
Thousands of dollars. Thousands. So that was suspect, you see. They appointed him 3 white lawyers. One of them was an excellent criminal lawyer. One of them was a civil lawyer, but he was good. And the other one was young, just out of law school, who could run errands. They tried the case, and when they tried it, by the way, they had deputy sheriffs all around the courthouse. You couldn't get into it. This man's family couldn't get into the courtroom. It was like like he was being tried with military with everybody. But anyway, they tried him, and it was an all-white jury, by the way. And blacks had never sat on juries in Hamilton County. But listen to this last day of the trial. I won't go into all the things that happened during the trial, but he had a very substantial alibi. But listen to the last day of trial. The foreman of the jury stood up in court and said to the judge, "Your Honor, we would like Miss Taylor to be brought back to the witness stand for further questions." And the judge said, "Oh, very well." So they brought her back in, and then the foreman said, "We want Ed Johnson to stand up in front of her." "Very well, let's stand up in front of her." Whereupon the foreman says to her, "Miss Taylor, for God's sakes, is this the right man?" Whereupon she said, "Well, I don't know, but I think so." Whereupon one of the other jurors tried to physically get his hands on the defendant, saying, "If I could get my hands on him, I'd cut his heart out." Now, they declared a little recess and things got going okay, so they kept on with the trial. But can one think that that's due process of the law? I mean, so anyway, they finished the trial, the jury started deliberating, and the news was that they were 8-4 for conviction. The judge let them go home that night. They came back and deliberated a short time, an hour or so, came back with a guilty verdict. And a guilty verdict for rape of a white woman was death by hanging. In those days, they hung them locally. You know, now you send them to Nashville or so forth, but in those days, each county, you executed the people in the local place. And when I started practicing law in 1961, there was still a place in the jail where they used to hang them. Anyway, they sentenced them to be hanged, but then the three white lawyers went before the judge and asked the judge, "Will you appoint 3 additional lawyers to confer with us as to whether or not we should appeal his case?" "Why, sure." They appointed 3 more white lawyers. And they met. Now the man had 6 lawyers. They met and discussed the matter, and they decided, well, he shouldn't appeal. So the original 3 went over to the jail and talked to Ed Johnson. And this is all a matter of record. They said to him, "Ed, well, we just don't think an appeal would do any good. We don't think there's any errors in the record and so forth, so we don't think you should appeal." They said, "More importantly, however, we don't think the public will stand for you to appeal. We think if you appeal, they'll break into jail and lynch you." And he said, "Well, I sure don't want to be lynched." Hell, he was sentenced to be hanged, you see. So they took him up before the judge and told all of that in court, and the judge says, "Very well, let him, he's waived his appeal." Next day, 2 black lawyers, and by the way, you could have gotten some of my money for me to discover that in 1906 there were 2 black lawyers practicing law in Chattanooga. Listen, there were very few black lawyers in the entire country. Anyway, the 2 black lawyers went before the judge and said, "Judge, his family has hired us to appeal his case." The judge said, "Well, what do you think you can do that these white lawyers can't do?" Anyway, he said, "Well, I don't have time to talk to you. I'm going to Florida for some rest. See me when I get back." He did, and they did. When they got back, they went to him, and the judge said, "Well, you only had 10 days to file a motion for new trial, and that time is gone, so you can't appeal." They later on, these two black lawyers, filed a petition for writ of habeas corpus in federal court, alleging that his federal constitutional rights were violated. And among those, they said, you know, that day, the last day of trial, where they said, you know, if I get my hands on you and so forth, they said that violated his rights under the 14th Amendment to due process of law. And they also said no black jurors on this panels and so forth, that violated his constitutional rights under the federal Constitution. And that the fact that they had like a mob-like atmosphere when they tried him with guards all around, like the military, around the courthouse and so forth. Well, the federal judge in Tennessee heard the case, the habeas corpus case. And if he found those things to be true, he could have granted a new trial to the man. Well, he heard it, and he decided against the man. But he did one other thing. He said, I'm going to give the lawyers 10 days to file a petition in the United States Supreme Court asking for them to hear it. He did. And they filed it. And the younger of the two lawyers, Hutchins, went to Washington, and you see, for each for each circuit of the federal courts, you have one justice that's over that circuit. And we were in the 6th Circuit. And the justice that was over the 6th Circuit was a justice from Kentucky, Harlan, who was the one who dissented in Plessy versus Ferguson in 1896. Plessy versus Ferguson held that segregation was okay with the Constitution. Well, he dissented. And he heard this lawyer make his argument, and he agreed to grant this man a hearing in front of the Supreme Court. But then the next thing he did, he submitted the entire matter to the whole court. And the whole court agreed that he should have a hearing in the Supreme Court. They sent the telegrams back to Chattanooga to the judge, to the attorney general, to the sheriff, saying, stop his execution, we're going to hear his appeal. That really teed Chattanooga off, you understand? The people back in Chattanooga didn't like it at all. And what happened was that the sheriff, you know that I told you originally when this thing first happened, people came down to the jail trying to get him out to lynch him. And then there all this to do about the trial and so forth, and then the Supreme Court. He left one deputy on duty. The sheriff did. And the sheriff later testified that he heard somebody was trying to break into the jail. So what does he do? He goes down to the jail. And he sees these people and so forth, and they grab him. But he doesn't put up any fight. He didn't pull his gun out. He didn't do anything. Then they take the black man out of the jail. It took them 2 hours to get him out of the jail. The reason they took him 2 hours is that one of the sheriff's deputies had the keys, and the mob didn't get to him first, so they started trying to break into and they broke the locks, messed up the locks, so it took them 2 hours to get to him. Can you imagine the fear that this man had in that jail when they were trying to break in to get him? Anyway, they finally got him out and took him down to the Walnut Street Bridge. And they went to the second span of the bridge. The reason they did is because in 1893, there was a first lynching from the Walnut Street Bridge of a black. And they